Well, this video is prompted by the recent death of Supreme Court Justice Antonin Scalia. And I don't want to talk about, his, history, his ideas about jurisprudence. I don't want to speculate about what this means for the court. I think it's obvious. What I do want to talk about is something that I alluded to a little bit in one of my satire videos for a little bit, but I think it's worth pointing out and elaborating in its own video and in a way that can't be confused as satire, because one of the problems with doing videos like that is people can't tell what parts are serious and what parts are not. And that is that whenever we have to talk about replacing a Supreme Court justice, adding a new person to the court, it becomes abundantly clear, either implicitly or implicitly, that the nature of the court is very different from the way people portray it when we are talking hypothetically about its role as a check and as a balance against federal power. Um, in in the process of having political debates, a lot of times we run into this idea that like federal power, government power is limited, and it's limited because of the Supreme Court. We have this system of checks and balances. That the legislature, they pass the laws, but then the executive enforces the laws, and then the Supreme Court, judges the laws, so to speak. And of course, there's other layers to that. There are people who say, well, then the states are a check against the federal government, and vice versa, and whatnot. But we are told that like this, state power isn't arbitrary, it's not absolute, which I actually agree. It's not absolute. The state can't do anything, but it's not. It's restrained by these legal restraints and this judicial body, among other things. And people talk about it like that, but then when we get an opening in the Supreme Court, it becomes abundantly clear that the decisions of the court are very much controlled by the membership of the court, and that by having the right judges on the court, you can render whatever decision you want, and that it's not really some kind of objective institution of august jurists who are going to dispassionately and vigorously uphold the law, but they're biased, opinionated people who are appointed for the reason that they are expected to act a certain way. All right, so if someone were to approach Obama and say, we have somebody who is a great jurist, their understanding of constitutional law and legal theory is, second to none, and their character is beyond reproach, that person is not going to even be considered if they don't have the partisan positions that Obama thinks that they should. And I say Obama, but we could be talking about any president. And this isn't a new thing. This could go all the way back. And this means that the entire idea that the Supreme Court is this check is fundamentally flawed. There's also another element to this where decisions of the court are considered, final, in the sense that we could talk about, say, gun control, and people could say, well, look, whatever you think is one thing, whatever you argue is one thing, but the Supreme Court has said X, and therefore X is true. Well, while I would concede that the Supreme Court has authority, because it does, it has authority, I would question the legitimacy of that authority and the extent of that authority, and how valid it is to then say whatever things these 9 lawyers decide, and not even consensually. I mean, they could have almost 4 of them could not agree, and 5 of them could, and it could be considered final. Um, whether that is really a strong argument. I was just listening to Tom Woods, who did a podcast about Scalia personally, and he quoted Joe Sobran, who I think is one of the sadly less well-known libertarians out there, anarcho-capitalists out there. He died several years ago, but interesting character for those who want to look him up. Very good writer. He was once asked, isn't it a travesty that in the UK the Parliament, the majority of Parliament, can amend the Constitution at any time. And he said, in the United States, 5 lawyers can amend the Constitution whenever they want, referring to the majority of the Supreme Court. They can basically, whatever they say the Constitution means is what it means. In the plain language, the original intent, or the whatever political arguments we can make about the benefits of this interpretation or that interpretation are completely secondary. The government is going to say it can do whatever it wants as long as the Supreme Court says it's okay. And then within the broader society, there's such a there's enough deference to the Supreme Court and the government generally. And I don't think it's total. There's a lot of anti-government sentiment out there as well. I don't want to deny that, but there's a lot of people who are going to say, well, I mean, if the Supreme Court says, then that's it. If the Supreme Court says Obamacare is legal because it's a tax, never mind the part that says, all bills that tax have to originate in the House and not in the Senate, and you have to have an apportioned tax and not an unapportioned tax and that kind of thing. The Supreme Court says it's okay. And if the Supreme Court says that, gun control is an individual right, then it's an individual right. And of course, if it says it's not an individual right, then it's not an individual right. And I mean, it's obviously problematic because the Supreme Court has gone back on itself many times. We can go back and say segregation is legal and then segregation is not legal. We can say slavery is illegal and then slavery is not legal. Uh, Although you could say, well, they passed the 13th Amendment, which made it illegal, so they were, following the law in each case. But if you're going to say, well, they're just following the law, then don't say then that the law is necessarily, moral or correct or whatever. Because if you're going to say it's moral or correct, then slavery is correct, and segregation is correct, and any of these other past evils, drone striking is correct. So I think it's fascinating when you're having a hypothetical debate about the role of government in society and the problems with the state, and you say, oh, but there's an incentive problem where these people are appointed by the government, they work for the government, they're very much biased in that sense. There's no way, it's kind of silly, and you don't even have to be cynical to realize there's a conflict of interest, and that it's wrong to kind of look at these people as a dispassionate third party between disputants. They're on the side. If you're having a dispute with the state and the Supreme Court is the judge, that's obviously a conflict of interest. But people will talk about it when you're having a debate about the legitimacy of the courts or the legitimacy of the state. They'll talk about it as if it is this dispassionate thing, this objective body of individuals who are you know uh, judging, between various parties who aren't biased and who are, great jurists or whatnot. But then, whenever someone dies, whenever there's a seat to be replaced, there's this enormous amount of vitriol. I mean, I've been taken aback by how pleased so many people are that Scalia died. Like, what has Scalia ever done to anyone? He voted. I mean, he voted against Obamacare, but Obamacare still passed. So I don't know where the vitriol comes. Is it the Heller case? Is it the McDonald case? The only things that I know that he has actually voted against and that then was overturned were the gun rights cases, which were pretty mild when you think about their implications. Um, but it shows that how people understand practically that this isn't something about an objective jurist who's just going to judge everything fairly. This is a political appointee. This is somebody who's going to wield, potentially enormous power, and that they understand that the fact that Obama is going to appoint someone is going to make a difference than if, say, Bush was to appoint someone. Now, my personal view is there's not much big difference between them. We got John Roberts from George Bush, and he's supported Obamacare. In fact, I think he even said it's not the role of the court to question what the legislature does, which of course is very interesting. If people are going to say, oh, it's a check, and then the Supreme Court justice that says, the Chief Justice says it's not a check, we're just kind of here to, I mean, in that case, find whatever rhetorical loop we can to justify whatever's been done, which, if that's what they're doing, of course, the cynical libertarian or even the skeptical non-libertarian anti-government person is going to derogatorily accuse them of being just that, a way to apply some kind of legalistic rhetorical veneer over whatever it is the government's doing, uh, he's essentially admitting that. And what these people who are so vitriolic about who's going to get appointed, and of course, all the conservatives are like, no, we can't appoint anyone now, and they're all admitting tacitly, at least, that this is the case, that this is a sham position, that this is something that you can engineer anything you want. There's I don't know if it's a real quote. This to me kind of sounds like one of those fake quotes, but it's an interesting sentiment. It's usually I've heard it attributed to Stalin. Maybe it goes to somebody else, but his quib was who votes doesn't matter. Who counts the votes matters. Well, and this is the case where you know who the Supreme Court justices are doesn't matter. Who appoints them matters. You can render. I mean, just imagine. I mean, you could say we can have elections, right, and we can have voting. But if you also say someone gets to pick who gets to vote, then voting is really pointless because they're only going to pick people who are going to render results that they like. The person who is making the decision about who gets to vote, and like I say that hypothetically, that is to a large degree what we have now, where the state does actually decide who the electorate is, and not only who can vote, but in what jurisdictions you can vote. And there's a whole issue of gerrymandering. But you can see how this very clearly can be used to engineer results. Maybe not always exactly specific results, but very near to that. Enough influence, enough insulation from popular will to render it very, very, not, if not necessarily totally void, much reduced in its potency from what it would otherwise be. And you can see that even stronger with, I mean, it's one thing to allow millions of people to vote and see what happens. If you are selecting exactly just a few justices, they're only going to pick people that are going to comport with their ideas. And this has a long history. There's a law school in my home state named after a jurist from the late 19th century named Cooley. I think his name is Thomas Cooley. But he was in the late 19th century a renowned constitutional law, and he wrote books about it. And he, everyone kind of at the time, de facto, he's the smartest, best lawyer, legal scholar in this field in the United States. And that was taken to mean that he would never be on the Supreme Court for that reason, even though he was fully qualified. So this isn't like an Obama thing or a Bush thing. This is all the way back. And indeed, the earliest, perhaps the most important purveyors of federal power relative to the other branches of government and relative to the states, and perhaps some of the most important minds in the shaping of the U.S. federal government, especially in the early republic, that falls not on someone like George Washington or Alexander Hamilton, but probably on George Marshall and Joseph Story and these other early members of the Supreme Court, of the first Supreme Court. These were people who, because of that position, had decades in the case of Marshall, I'm not sure how long in the case of Story, to basically propagate their vision, at the time what we would call federalist, although kind of not federalist, more of a centralist, a central person in favor of a central state, to put forth their ideas and shape the history from there on out in a very strong way, more so than most people realize. I mean, like Washington and Jefferson, these people get a lot of credit, but it was Story who, not Story, it was Marshall who kind of uh, uh, elucidated the idea of judicial review, where the court gets to decide what the Constitution means. And I've used this analogy. It was one of the first analogies I kind of came up with way back, long before I made YouTube videos. But I could say, because some people like to look at the Constitution as a contract, and they view it in that way, like, oh, this is a contract between the government and the people, and they have obligations, and we have obligations, and whatever. And there's lots of problems with that. But one basic problem with that, a fundamental kind of theoretical problem, is you and I or whoever could draw up a contract, and we could put in all the clauses in there and all the variables, and we could outline all the things, and this is how we're going to do everything, and this is how we're going to divide our profits, and this is what we're going to do if we have a dispute. But then it will say at the end, whenever there's a disagreement about the terms of the contract, I get to decide the outcome of that dispute. then the entire contract is meaningless at that point. If I'm the arbiter of any dispute, then the contract means whatever I say it means. And it could very clearly say, I'm entitled to, we're splitting the profits 50-50 all the time, no questions asked. And I could just take 100% and you could say, no, that's wrong. Like, okay, we'll have a trial about it. But since I'm the arbiter, I'm going to decide. And I can decide any way I want, and you have no recourse because I'm the person who decides. And this is like a blatant problem with the system. The government is an arbiter of its own power. And the idea then that, oh, this court is going to be an arbiter of the government power is just laughably absurd. And when people use that as an argument, like we get in practical debates about this, maybe the efficacy of a policy, whether it's gun control or healthcare or welfare or surveillance or whatever, and people say, well, but the Supreme Court has said this. If we have a debate on even things like copyright or patent law, people will say, oh, but the Supreme Court has said this and this, and they're talking about the Supreme Court like it's this. They're not talking about the real court, because if they were talking about the real court, they'd have to admit, okay, it's biased, it's politically appointed lawyers who reflect the whims of a very biased politician, the president. They're affirmed by other very biased political politicians, namely in the Senate, and that as such, their decisions really shouldn't carry all that much weight. They're not necessarily correct. They're not necessarily judicious. These people were selected because they have certain biases, and that's why they're there in the first place. But rather than couch it in those terms, people couch them in much more laudatory terms, and much more, this decision indicates that whatever it was is correct. That they have authority in such a way that we don't need further argument because the Supreme Court says so. But that is a hypothetical government. And I've said this before. So many arguments about the state don't argue about the state that we have, or the state that we hypothetically could, or the state that we historically has hypothetically existed, or has actually existed. It's a hypothetical state. It's the state that isn't corrupt. It's the altruistic state. It's the state that has politicians who know what's best for everyone, or even care what's best for everybody. In some cases, the people are making assumptions about a benign state. They're assuming that that everyone in the government is actually motivated primarily by helping other people. Now, that's obviously not the case, and if you're making an argument for the government that's based on that assumption, it's wrong. Now, there's obviously less ridiculous hypothetical governments people talk about where they don't necessarily assume benevolence on the part of the state, but they assume, well, okay, they're trying to get ahead, they're selfish like anybody else, but because of appealing to voters, they have an incentive to try and do what's best for the greater good or whatever else. And like, there's problems with that as well, because how do they even know what the greater good is? And there's rational ignorance on the part of the electorate, and also there's very strong incentives to cater to special interest groups who then can reward you in some way or another, whether it's directly with cash and bribes or indirectly in any number of other ways that can never really be stopped. Not to mention, ideological biases where a president could, a politician or a government official, they might not be motivated by direct avarice or direct will to power, although that is a very real thing that is present in government, but who still might have their biases. We might argue that, say, someone like Bernie Sanders really believes that what he's going to do is going to help people. But that doesn't mean that the fact that he believes it makes it true or makes it optimal or makes it very good. So there's a very common thing to talk about a hypothetical government where, like, it's almost like, and Scott Horton has used this analogy before, people imagine that the statue of Abraham Lincoln is kind of running the show up there, that it's these marble figures, founding father, very wise, judicious, objective, whatever that means, elites. I mean, people, it's funny that there's all this egalitarian rhetoric out there, but at the same time, the fact that they vest these people with so much power and other people with not vested that amount of decision-making power, that is a clear indication, no, that you consider those people to be anointed in a way that others are not, right? If you're a true egalitarian, then there's no reason to say that person should have the right to govern, and all that that entails, and not everybody else, only that one person or that group of people. That betrays a very stark inegalitarianism, a hierarchy, a very, very pronounced hierarchy in the case of the government that we have today. And I think that that's very interesting. And I think it belays the lie that people understand that the Supreme Court is not some objective arbiter of between right and wrong and the Constitution and legal theories. That it is a political body that will perpetuate whatever it will be an extension of the will and the biases and the preferences of the president who appoints them. And I mean, there's many famous cases of this. Maybe the most famous is the court packing scheme of Franklin Roosevelt. That was a case where early in his presidency, the court started overturning many of the articles of the New Deal, the AAA, some of the laws about um, minimum wage and certain things like that. And then FDR said, okay, well, I'm going to the number of justices is not actually set in the Constitution, so you can appoint more justices. And he thought of the idea of we're going to appoint a new justice for everybody over the age of 70 who's on the court. The idea, because there were several people on the court who were over 70, and the purported logic was the over 70-year-old justices are too tired to handle the workload, and so we should appoint younger justices. But the clear implication was these new younger justices would all be pro New Deal, they'd all be pro FDR, and that once their votes were added to the chief that of the Supreme Court, they would be able to vote in the majority against the original justice. Now, this was so blatantly an attempt to grab power at the expense of the judicial branch. There was a backlash even within FDR's own party, something that is just not understood today, and it never happened. However, it cowed the court. The court became very aware that they are subordinate to the president and to the executive and to the legislature, that they are dependent on them. And after that, subsequent laws were found to be constitutional. And there was, in fact, Napolitano has pointed this out, between, I think it was like 1936 or 1937, in the mid to late 30s, that was the last time the court found something unconstitutional, all the way up until it was either the McDonald case in 2008 about the gun control laws in Chicago, or maybe something in the 90s. In either case, you're talking 70, 80 years. And it's like, how do you have to be cynical to realize that's impossible? If the federal government didn't pass any unconstitutional laws in that amount of time, then the Constitution doesn't mean anything. And it doesn't mean anything as far as the courts, as far as the federal government is concerned. Now, we could argue that like judicial review is not actually in the Constitution, and that federal judges, that's their say so, but this is the way the government views it. And so, if you vest any authority in the government and any stock in their definition of what's right and what's wrong and what's constitutional or not, that kind of paints you into a corner. So, obviously, Obama is going to appoint some horribly leftist, thinks the government can do anything type justice, just like he did the other ones that he's appointed. I don't know that much about Scalia. I'm not mourning his death. I don't think it's going to make a huge difference one way or another. I don't know how much his vote did to change anything. The big thing that should have, I would have liked to see overturned was Obamacare, and it wasn't. And obviously, it was a 5-4 decision. Now it's going to be a 6-3 decision. Oh, whoop-de-doo, doesn't make a big difference to me. I think it's very illustrative, though, that the reality is people understand what this really is. But if that's the case, then they shouldn't be disingenuous, and when you're having an argument or having a discussion, pretend that it's something that it's not. It's one thing when we get into the gritty details to acknowledge it's a political process, it's about power, it's about influence, it's about ideology, and it's not about what's right or what's wrong or what's optimal in some kind of economic sense. And then when they defend the government, defend it as if it's this hypothetical ideal, and they say, oh, no, I mean, you can't be against the government because who's going to be the objective, who's going to arbitrate disputes when there are two parties getting in an argument. We have to have a hegemonic deity institution that does that. And okay, I mean, is the government, such an institution? Is it something that can objectively do that? And the answer is obviously no, not with itself. And we're all taught, well, we're having disputes with the state all the time. So I think that's what's really illustrated by this. Now, it's something I've thought of before. I don't remember which of the videos it was, but in one of the satire videos, I did talk about that. But it's very clear just how, I mean, I don't even know how many fucking moronic liberals I have on my Facebook feed who I don't think they would even know who Antonin Scalia was had he not died, but who are posting like, "Oh, thank God he's dead," and like, "Oh, this is so great, great news." And like, why is it great news? I mean, if the Supreme Court is just this, um, detached, objective body, then they're just going to appoint, the most, um, technocratic guy. This is almost sort of like, maybe not the best analogy, but like the Chinese examination system, where the people who got appointed to rule the provinces were the people who got the best scores on these very difficult examinations that were administered by the court. And if you just got a really high score, if you could write really good eight-legged essays about the Analects and about Mencius and Confucianism, then you could end up running a province of Sichuan, with 20 million people in it. Um, and of course, that that system didn't really work that well either. But that's not the system that we have, and that's not the system that's ever existed. And so, don't argue for it as if that's the case. So anyway, um, that's pretty much it. And I'll talk to you all later. Bye bye. Wow, under 30 minutes, losing my touch.